Hi, thank you for joining us for TendingBar. My name is Todd Harris, and in this episode, we'll be talking about some serious things and some really good news. I want to start by a little show and tell. This is my trusty copy of To Kill a Mockingbird. It's really a prized and cherished item in our household because it's signed by Harper Lee. It's an autographed copy. To Todd and Angie, best wishes, Harper Lee. It was a wedding gift when we got married, back when we lived in Alabama, and friends of ours who owned a bookstore asked her to sign that for us. To Kill a Mockingbird is one of the most widely read books in the English language. Children across the United States, of course, read it in middle school or high school. I had the good fortune to visit Monroeville, home to Harper Lee, just a few years ago for a conference where executives from China were visiting Alabama to consider investment there, and they all descended on the George Wallace Community College there in Monroeville. And I learned from them that To Kill a Mockingbird was required reading for every school child learning English in China, and that it was, in fact, in China, the most widely read English book. Really a remarkable piece of literature, a Pulitzer Prize winner. And it tells the story, an important story, of an attorney with integrity, Atticus Finch, standing up for a defendant and protecting someone whose defense was unpopular, but turned out to be innocent. Really important story set in the 1930s in a fictional town in Alabama, much like Monroeville. And it seems like such a thing of the past. But as we've all been reminded recently, it's not such a distant past. You may have seen the movie Just Mercy, which has just recently been in theaters. I recommend it. It's a wonderful movie. It tells the real-life story of Bryan Stevenson, who founded the Equal Justice Initiative in Montgomery. But in particular, the Just Mercy book and the movie based on the book tell the story of Bryan's defense of an innocent man who had grown up, you guessed it, in Monroeville, Alabama, and had been wrongfully convicted and had spent years in prison not too long ago. What shocks me about that story, told by Bryan Stevenson in the movie, is that I lived in Alabama at the time the man was convicted, and it was, and at the time of the appeals, and at the time he was released from prison. And what's amazing about it to me was I don't remember a thing about it. I don't remember it being in the news or a big issue. Such an important thing as finding and achieving justice for someone wrongfully convicted didn't even register on the news. Well, let's not let that happen. Those kinds of events are important. And today, we're going to celebrate a victory. We're going to celebrate something that happened just a few days ago, actually. The story of a wrongfully convicted man released from prison. And as you know, on TendingBar, we are celebrating sort of the higher spirit of the legal profession and hearing the stories of lawyers who have a sort of calling to the cause of justice. And today we're going to do that by talking with my friend and partner, Mark Schamel. And he'll get to tell us his story, this true life story that we can all celebrate. So right now I'd like to introduce you to Mark and say hello. Mark, you're on the air. Thanks for joining us.
Thanks for having me, Todd.
Yeah. So listen, I'm very excited to hear about these recent developments, but let's take just a minute to hear a little bit about you and your practice to set the stage for this recent story. Just tell us a little bit about how you came to be a lawyer in the first place. Why did you become a lawyer?
Probably because I didn't have really a lot of other discernible job skills. I'm terrible at math. I was never going to make it as a doctor. I went to law school straight from college. First lawyer in my family anywhere that we can tell in any of the families in any direction. And candidly, went to law school, having been an intern at the U.S. Attorney's Office when I was in college for the homicide division in Washington, D.C., and really thought that's what my calling was going to be. I was going to get into criminal law, and I was going to do it on the prosecution side. I got an offer with the FBI out of law school and a couple of pretty well-known prosecutors' offices around the country. I was going to be a prosecutor. Unfortunately, I just had a lot of student loans and I couldn't afford prosecutor starting salary. And so I hooked on with a small defense shop, little boutique, and thought, well, I'll do this for a little while and figure out sort of where we are. And here I am 22 years later. I'm a career criminal defense lawyer.
So that's maybe not an uncommon story that folks who come out of law school today and they have a lot of debt. And so they, instead of going to work as a public official, go into private practice. But you're an illustration of how that doesn't mean that you stop serving the public interest and the public good. As a defense attorney, you've defended all kinds of defendants, but you've sort of developed a specialty in defending law enforcement officials. Can you tell us a little bit about that?
Sure. I've handled a lot of cases representing law enforcement officers, both federal and state. I've done it sort of around the country and even outside the country. I had a pretty well-known murder case. I represented a federal agent about 10 years ago at this point in the U.S. Virgin Islands, which was a experience and a story for another day. But yeah, I actually got into it sort of in the same way I got into my legal profession. It just sort of happened. I had a lot of relationships with folks at the U.S. Attorney's Office, and I'd become a lot of friends, a lot of police officers and such. And so the shop I was with, we just started representing officers. And then we started getting calls from other officers and started getting calls from the insurance that some of these officers and the unions would get to represent them. And that sort of morphed into the Department of Justice asking me to handle some cases. And now I get calls. For example, remember that poor woman who had mental illness who came out from Connecticut at the end of the Obama administration and tried to drive into the White House and tried to drive up in the Capitol. I represented 2 Secret Service officers that shot and killed her when they were initially investigated. So I get calls from government agencies, DOJ, because of the conflict issue. They have the defense counsel to represent them through those investigations.
So I can imagine when public officials are accused of wrongdoing, criminal wrongdoing, that being their defense counsel is not always popular. Has that been challenging at times? Do you find any pressure against taking on those sorts of defense?
No, I would represent anyone. I have one quote over my desk at the office back in our pre-COVID days when we all sat in desks, and it was from John Adams. In his memoirs at the end of his life, he's always credited with saying that the most important thing that he did, the second president of the United States, the first vice president, founder from Boston, and the most important work he ever did was as a lawyer representing the British soldiers that were charged with murder for what came to be known in the revolution as the Boston Massacre, and getting those men, not all of them acquitted, but certainly sparing them the death penalty and sending them back to England. And he thought that was his greatest service to the country. And I have, from my law school days as a clinical program, and frankly, some of the people that work with the U.S. Attorney's Office who just believe so strongly in justice and doing things the right way, I have become a real believer in our Constitution in a very sort of fundamental way. And I think our Sixth Amendment right is one of the things that truly distinguishes us from any place else in the world.
So for viewers not well versed, explain to us our Sixth Amendment right.
The 2 things I think that are most important in the Sixth Amendment, and I'm sure there's some constitutional scholars who watch this and say, but Mark, you missed. I think it's your right to counsel. Right. And that was then passed on to right to everybody to have counsel, even if you couldn't afford counsel, through the famous Gideon case, Gideon v. Wainwright. And it's also the right of confrontation, right? The idea that you get to confront those who would make allegations against you in a public trial. And I think that is, sort of next level. I'll tell you 2 funny sort of anecdotal quirks. One is I have a dog named Gideon. And the other is that, because I'm also married to a former public defender. And the other is I was in the UK just before the pandemic, and we were giving a talk, one of our partners over there who does the same work I do, but on the UK side. And we're giving a talk in Scotland about sort of, the differences between when you have these parallel investigations, you have cross, between the SEC and the FBI and the DOJ and these different, and the Serious Fraud Office in London. And you have these cross-border or cross-ocean investigations where they're sort of working hand in hand. And so I was on the plane flying over, and I watched this film about a whistleblower, this woman that was a whistleblower with Rachel Weisz. It was a very good film, and it was about, she was a whistleblower during the whole run up to the Iraq War. She worked for basically their CIA or NSA, the equivalent in the UK. And when she was caught, she was brought in, and they assigned her a lawyer for interrogation. And I remember watching this scene on the plane as we're flying across this in the middle of the night. Like, I can't really sleep, and I'm watching this, and the lawyer is sitting next to her, and Scotland Yard is interrogating this woman, and the lawyer is saying nothing. She's literally just sitting there saying nothing to her while she gives this full, complete confession. And I woke my wife up. I was like, what's happening here? What is going on? And I remember when I got to the UK and I landed, and I was talking to some of my colleagues, I did some research on it. Like, that's what they do. They don't have this Fifth Amendment right, of remaining silent. And the lawyer literally just sits there next to you while you give this confession. Now, it's different how it can get used and what have you, but it's just what we have and what our lawyers are supposed to be doing is so different than any place else in the world. And I believe it with all my heart. So yeah, they're unpopular, but I would represent all of them.
So part of the project of TendingBar is to think about the values that our legal system is trying to serve, and to in relation to that, think about the motivations of lawyers who are serving that system. Presumably, with the right mindset, we're all supporting those values that the system we support is serving. And so, you've just talked about the right to have counsel, the right to confront our accusers. But I wonder if you can, before we turn to our case for today, talk to me just a little bit about our system of jurisprudence that's based on process, and what are the values that we're trying to protect there.
There's a lot of rhetoric, right? There's a lot of just sort of discussion about what it means and what it's about, and we're constantly getting eroded because it's run by human beings, right? I mean, we have these great ideals, and it's like anything, whether it's our electoral process or what we're doing as far as picking our leaders or thinking about what our policy is going to be, financial, economic, all the things that we're doing, our, healthcare policy. We have all these great ideals, right? And the law is supposed to have codified a lot of these ideals, and the idea that the prosecutor has a fundamental difference, right, in what they do to what I do. We have the same ethical guidelines, the same rules. We're bound by the same criminal procedure. But a prosecutor, first and foremost, is supposed to do justice, right? They are not supposed to indict somebody that they don't believe that they can prove their guilt beyond a reasonable doubt. They're not supposed to go forward on hunches. They're not supposed to settle political scores. They're supposed to be sort of superhuman in their ability to be objective above all else. And the reality is that just doesn't happen. It's a very rare human that you can meet that can do that. I've met some that I think are at that level, right? That they can say, I can separate out whether or not this person is a member of the Klan or a member of the Muslim Brotherhood, or, has taken a pledge to kill all Jews or blacks or any sort of horrific thing that you can think of. And make a decision based on the law, make a decision based on the facts. Because, there's a lot of people that are running for higher office. There's politics involved. There's public outrage, right? And I always laugh when I see these people that are sort of, you think of them in sort of a left-leaning sort of liberal view, and they're like, get the pitchforks, get the, because it's something they believe in, right? It's like, it's something that they're against. And it's very hard to block out that sort of background noise and focus on doing what's just and what the policy is supposed to be. And to what we're going to talk about, I think the problem is we haven't mastered yet in the criminal justice system in this country. Make no mistake, I think we have the best criminal justice system in the world, but it's by no means close to perfect. It's very
So
flawed.
we've talked about this before. So I think the general public doesn't think about our criminal law in these terms, but we have a procedural justice system. If we think about, I'll use the term substantive justice to mean in a particular case whether we actually get the verdict right. Did the person really commit the crime or not really commit the crime? If we get that right, that's substantive justice. But we have a procedural, not substantive, justice system. That is to say, we've got a set of rules that we follow that are designed so that, on balance, most of the time, we will tend to get it substantively right. But given the shortcomings that you just described in human nature that we acknowledge, we have put in place a set of rules that are intentionally slanted a little bit, so that we have a preference. We have a preference based on our rules are expressing our preference. We would rather get it wrong and let a guilty person go free on occasion than that an innocent person should be found guilty and have their liberty taken, or in some cases, their life taken. Would you agree with that characterization of our procedure?
I would, in the sense that we have gotten it right if a guilty person walks out of the courthouse acquitted, even though they're technically guilty. They did the thing, right? They did the thing that they're accused of. They had the criminal intent that was required. They did it, but you couldn't prove their guilt beyond a reasonable doubt. Then procedurally, that is just, right? That is what we're supposed to do. You're supposed to. It's okay to be upset about it. It's okay to, as a member of the jury, to say, and you see these all the time, I think he did it. I wasn't convinced beyond a reasonable doubt. That, to me, is the ultimate justice, right? That means you've gotten it right procedurally.
We have a recognition, it seems, that if in a given case a prosecutor says, I'm just sure, I'm confident that this particular defendant is guilty, but I don't have the evidence to prove it beyond a reasonable doubt. In that case, if the prosecutor manufactures evidence because they're just sure, what if they're wrong? Maybe they're right in that case, but if it becomes the rule that they can bend those procedures based on their inclination of who's wrong or not, who's guilty or not, that we'll start to we'll have less and less substantive justice. And because the justice is the determination of the prosecutor as opposed to a jury of our peers after a hearing and a right to confront our accusers, right? So those procedures are a lot about evidence and about the validity of evidence. And that's going to play, as it turns out, a big part of the case that you're going to tell us about.
Yeah, I would say this, though, Todd. I think it's important to realize that at some level, that has already happened. Prosecutors already have that power. When a prosecutor has a decision, because the prosecutor has the sole discretion on charging, right? And so a prosecutor can charge, and because, I forget last count, there's 40,000 different laws that are on the books, right? You look at the federal and state statutes that are available. Because a prosecutor has the ability to charge and perhaps overcharge and make defendants make a decision. Well, if you be guilty to this charge, you'll be a felon, but you won't go to jail. If you refuse, if you maintain your innocence, if you maintain that you didn't break the law, I'm going to indict you as somebody that has a mandatory 5 years, right? That happens across this country on a daily basis. Now, I have yet to see, and I'm just thinking if I've ever could even think of anybody that's close to it. I've seen some prosecutors I think are very unethical. I've seen some prosecutors I think have a moral compass that is not tuned to true north. I've seen prosecutors that do things that have motivations that are clearly not about doing what is right. I have never, in 22 years, a couple thousand cases I've been around and been involved in, I've never seen a prosecutor intentionally, knowingly manufacture evidence. Right? What I think happens is, and you're starting to hear more and more of these discussions from these innocence cases, right? Outcome bias, right? The need for double-blind photo arrays to avoid, any unintentional finger on the scale type of situation. I see prosecutors and police officers succumbing to outcome bias all the time. And what that means is they think they've got it. And so then they end up with this myopia of focus on what they think happened. And we all know, we all learned in high school or middle school, you sort of find what you're looking for, right? And so they discount other evidence that would tend to exculpate a defendant. They discount witnesses, and and it's not very often, I would say almost exclusively, it's not the result of malice, right? I think that the prosecutors, I know some of my closest friends are prosecutors. I was going to be a prosecutor. I think that they go into it for the right reasons. They think they're fighting the good fight. They believe they're wearing the white hat, but they don't have sort of the objectivity because they're human. Right?
I guess it's really important to point out, though, right? This is not an indictment of any particular prosecutors or police officers as a class of people. This is just saying they're human like the rest of us. And so they're going to see things from their perspective, and they're going to have the shortcomings that all human beings do. And that's why we have to have defense counsel involved, even in unpopular cases, even where the defendants are unattractive or repugnant even. They deserve a defense because they might be innocent.
This is why that's right. Or part of my job is just to defend the Constitution, right? Part of what I see myself doing is if I have somebody to be like, how could you defend that person? I'm like, look around. That person is you and me, right? I mean, most often it's a split-second decision. It's a series of life events that occur to somebody that get them addicted to drugs or mental health issues or be desperate enough to do these things, right? Very rarely do people of reasonable sanity without any other sort of impacts on the outside forcing them go to a life of crime. It's a very small percentage of these quote bad people, right? There's often a lot of explanations for what that happens. And in those moments, sometimes my job is simply to try to find a way to mitigate it, to bring forward this mitigation to show the prosecutor and the jury why this is situational and not sort of a core value or lack of values of that person. I also think that what happens is that if you make the assumption that all the evidence, all the things your eyes and your brain are telling you are true, and that person's not worthy of defense, isn't that first step off the ledge of denying due process to everyone? Right? Because the Innocence cases, and I want to talk about one in a second, we're breaking the record every single year. I mean, you've recommended this movie, which I think everybody should see. There's a couple of wonderful books out there. One, my favorite, is Picking Cotton, the story of Ronald Cotton and his false identification and then later exoneration by DNA after 20-some years of rape he didn't commit. There's a new Netflix special that just dropped last week called The Innocence Files. I'm only about halfway through, but I can say episode 8 is my buddy Brian, who got a guy off death row for a crime he didn't commit. And there was a certainty of everybody in that case that they thought that person was guilty. And why would he get it? Why would he need a defense? Why would he need a defense? And that's all the way up until you say, oh, shoot, because he's actually not guilty. He's actually innocent, right? And that process has to play itself out. So the joke I always make when people come to me and they're like, embarrassed or uncomfortable about what they're accused of or what they've done, I say, look, it took me a long time to come up with this, and it's crazy, and you may not want to put this online, but if you were to kidnap, rape, kill, and eat little children, and then walk around wearing their skin, it's the most horrific thing I ever imagined. It took me some time to really think of what's the most horrific thing. I would still represent you. I would still represent you, not because I think that you doing that, you should be acquitted or be back on the street, but I think you have an absolute right in our system to due process and a right to effective advocacy. And the government has to prove the case, because the minute the government stops having to prove their case, we are right back to where we were with the king, which is why we have these 10 amendments to begin with. These are the rights the king wasn't giving us.
And by providing that defense in the individual case, you're also preserving the system so that we aren't changed by the fact that the crime has occurred, that we stay true to our values and continue to ensure that we are the kind of society that we want to be. We're talking in the abstract, but I'm hoping that we can think about all those things as we hear this really wonderful story. Starts off with a sort of dark side, but it has a happy ending. Currently, at least, and I'm hoping you'll tell us a little bit about this case that you've been involved in. Tell us a bit about what's happened and how you came to be involved with it.
So in 2000, I was just trying to figure out the other day, in 2012 or 13, I think it was late 2012, I got a phone call from the director of the Mid-Atlantic Innocence Project. And she called me and she said, Mark, I've got a case. I need you to take it. And the client's innocent. And I said, well, you're the Innocence Project. What do you need me for? And she said, well, we can't, it's not a case we can take because they really have to focus on cases of exonerations. They need to be able to prove innocence because, as we're talking about, there's a lot of people out there that don't believe it. They think these people are walking off of death row and out of lifetimes of prison because of some lawyer tricks or some gamesmanship or something, when in fact, they're being exonerated. New technology is coming along. Old technology is being debunked for what it was, like bite technology, and you're getting DNA prevalent. And so they really focus their very limited resources of the Mid-Atlantic Innocence Project on the cases where they can do that, where they can show definitively with scientific evidence the innocence of the person. And this case just wasn't a DNA case. It was a series of other things. And I said I had no time to do it. I do a fair amount of pro bono, but I knew this was a huge sort of undertaking. And I had just come out of a couple of big cases, and I just wasn't in a position to be able to do it. She said, just agree to read the trial transcript. So I did. I read the trial transcript. And when you read a trial transcript, you realize you can do a better job cold than the lawyer was doing who had that case for months preparing. It sort of starts getting your juices going. And I realized I had, and my client actually even pointed out the other day, the first 2 years I had this case, I never referred to him as innocent. I always referred to him as not guilty, because I was 100% convinced very early on that he had been denied due process, that the system, the process had failed him in every regard. The police investigation, the conduct of the prosecutors, the conduct of the judge, the conduct of his own lawyer, the appellate process, which I always feel, and I think anybody would agree, is more focused on finality than on getting it right. And it was clear to me he was not guilty in that regard. And at a minimum, he should get a new trial. And now I sit here 7+ years later, and I'll sort of jump to the spoiler, which is he walked out of the maximum security prison in Cumberland, Maryland, last Wednesday at 2:08 p.m. And he's the first person to ever walk out of that prison directly.
So tell us your client's name. I think we might have had a glitch there in the audio. Tell us again.
Yeah,
Matt Horner.
Matt Horner.
And Mr. Horner was accused and then convicted of what crimes?
So Matt had a wife who has a series of other sort of issues, and she had the relationship had fallen apart such that he wanted a divorce, and she was going to be out because they were living in his father's home, and he had taken up with another woman, and she made a false allegation against him of domestic violence. And then following that, when he got released, she came up out of the basement. He didn't go back to the house, which we've been able to show. We can talk about in a second. But she came up out of the basement wearing a white bathrobe. Her hair was wet. She had a towel of some kind around her neck, and talked to Matt's father and stepmother, and was not really making sense. They couldn't figure out what was wrong with her. And it turned out when she got into the ambulance, the EMTs, they called the ambulance, and the EMT said to him, what happened? And she said, she made like a gun sign. And the EMT looked, and sure enough, she had an entry wound in her chin, went up through the floor of her mouth, through her tongue, through her palate, and came out in her forehead. And they had no idea nobody knew she'd been shot. They couldn't figure it out because she didn't present. She wasn't covered with blood. And then the EMT asked her, did your husband do this to you? She shook her head no. Later at the hospital, after some interviewing by the detective, in writing, because she was slipping in and out of consciousness, it was all hooked up with tubes and such. And we actually have the notes where she said initially, "Did your husband do this? Who did this to you?" And she shrugged. And the detective said, "I think your husband did this to you," which is a completely reasonable assumption, and with a alleged history of domestic violence. And she then agreed, and that was the only path they pursued. They found the scene in the basement was covered with blood. Her bloody clothes were all over the floor. She had clearly, and nobody contradicts it, she had changed her own clothes, cleaned herself up. She'd smoked a cigarette. There was a blood-soaked cigarette in the ashtray. Yep. And she became a celebrity in Baltimore with the House of Ruth and all the domestic violence groups, some of whom I've actually worked with representing actual victims of domestic violence. And she then went to trial and testified that Matt had gotten released from jail, come to the house, come into the basement, shot her, changed his clothes, and then left. And with no real explanation of how or why she got cleaned up, or the gun got put away, or she had the shell casing in her purse, or denied to the EMT that this had happened. And the things that her lawyer didn't do would take an hour to explain, but he was brand new. It was his first trial. Didn't do any investigation, didn't interview any witnesses, didn't talk to the experts. It was horrific. It was just horrific. And what we were able to show with help with his original post-conviction counsel was that there's documentation he got released just before 7 a.m. from this allegation of domestic violence that she made. And his father picked him up, drove him home. It's about 2 miles. And at 7:02 a.m., he called his girlfriend and said, "I'm in the car. I'm on my way there." And there's an eyewitness from next door who was found who said, "I saw them back into the driveway, him get out of his father's car, get into his truck and drive away," which comports with the 7:02 call. Pops, the father, said he came in the house and she came upstairs. And at 7:08, Pops' wife called the EMTs. So the government would have you believe that he got released from jail slightly before 7 a.m., drove home like Mario Andretti, ran into the house, shot her, ran out of the house, got in the car, drove away. The neighbor's lying. And she was able to regain consciousness, get up, change off all her bloody clothes, quell the bleeding from the 2 entry and exit wounds, clean herself up, put on a white robe, smoke a cigarette, and come upstairs all in about 8 minutes. And what we've been able to do is go after them on a broad procedural grounds. And the court, the chief judge in Baltimore, vacated the conviction on February the 5th on the basis that it was an unconstitutional waiver of Matt's right to a jury trial. I think that his lawyer was a little bit afraid of a jury trial. He'd never tried a case, and told Matt, "My dad helped this guy get elected. He'll be good for us." And I think also the other part was the jailhouse informant that testified falsely against Matt.
So going to that, so at the trial, another inmate testified. How would he have testified? What was the substance of his testimony?
So Matt was held pre-trial. He originally cut out, but then his wife, he was stalking her. We know it was false because A, she was in hiding with House of Ruth, and B, he was allegedly stalking her in a car that had already, unbeknownst to her, been returned to the dealership. So they didn't even have access to the car he was allegedly driving around stalking her. So while he's sitting in jail, as most people do on a case like this, awaiting trial, innocent, pending trial, he was locked up with a guy named Richard Schaefer. And Richard, turns out, had a 25-plus year history as a paid confidential informant of the Baltimore City and Baltimore County Police Department. He was pending sentencing. He'd just been convicted. He was looking at a mandatory 10 years with guidelines of 20 years. And he went to the police, his handler, who'd gotten him out of jams for all those years before, said, "Matt admitted all these things to me. And here are the notes I took when Matt was locked up. We were talking in the jail." And he testified that out of the goodness of his heart, he was going to testify and tell the truth that Matt had shot and killed his wife, or shot and tried to kill his wife. And there's a couple of interesting parts about that. One is that he made a number of other allegations against Matt that were all demonstrably false. So that Matt killed his first wife by shooting her. And we have the document. In fact, the detective at the post-conviction hearing had it in his actual file. I got that from him during the post-conviction hearing just a couple of years ago, showing that Matt's first wife died of a drug overdose. So there's all these demonstrably false facts that Matt allegedly admitted to. that nobody pursued. The government didn't pursue, they didn't turn him over, and his defense counsel never pursued. And then the other part was he said, I'm doing this out of the goodness of my heart. I'm facing mandatory 10 years. And 2 weeks after his testimony, he walked out, time served, 11 months. Benefit of having testified against Matt.
So that's the case as you found it. And you were able to obtain exculpatory evidence in several forms, including the neighbor's testimony about his departure before entering the house. But importantly, you also were able to get the testimony of that prior witness, the former inmate, and of the ex-wife. Can you tell us about that?
So the reason that this case came to me was this is sort of what I call a shoe leather case. This wasn't going to be a case that you're going to win with. Don't get me wrong. There was a lot of drafting and a lot of pretty voluminous motions that were filed both in the federal court, and we had to go back to the state court, and then come back to federal court again before we got the conviction vacated. And I just point out that the state has noticed an appeal, but through the Attorney General's office, they have agreed that they are going to reinvestigate this case, which is a tremendous concession. They are going to look into this. They have fought us tooth and nail for the past 7 years, and they fought Matt for the entire 15 years he's been incarcerated against a new trial. Both of the prosecutors are now state court judges, and I think this has a lot of repercussions. Some of the things that came out, but we were able to get this case reversed on 2 grounds, and there's a third ground that's hanging out there. The first was the waiver issue on his constitutional right to a jury. And the judge found, I think very rightly, based on Supreme Court precedent, that was not a knowing and voluntary waiver. And so that was ground number 1. And that was just sort of the legal arguments on the record. Grounds number 2 were all of the myriad ways that there were violations of Brady. And Brady is, for those that don't know, Brady versus Maryland, which is probably the seminal case in criminal justice in the 60s, which says the court mandates that the government must turn over to the defense any evidence that is potentially exculpatory, and they must do so in such a way that the defense can make use of it. It's not a timeline, but they have to turn it over for trial. So you have to have known when this detective went out and found that when Richard Schaefer said Matt killed his first wife by shooting her, and the detective went and found her autopsy report, right, and obtained that, and had it in his file, he should have given that to the prosecutor, and the prosecutor should have given it to the defense, because the defense can say, but Mr. Schaefer, you lied. He didn't admit to you that, because that's not even how she died. And there's all these various aspects of that. And so the court overturned it on the conviction on those 2 grounds, the waiver of the jury trial and all of these Brady issues, some of which relate to Schaefer, some of which relate to Lorraine, the ex-wife. And then they've held sort of off to the side this ineffective claim. They said, I'm not going to even reach it. It's a moot. I've already vacated the conviction. If the Fourth Circuit disagrees with me, I'll rule on it at that point. And that's sort of where we are procedurally. And factually, the running it down was you just had to start digging. And so, we found Richard Schaefer by finding his girlfriend at the time, who led us to his current girlfriend, who led us to Richard, who then recanted. And probably one of the most interesting moments of my career when he confronted me in the parking lot.
And he recanted his testimony.
That's the sketch, correct. He did. We took some multiple discussions, and he tried to get some money out of us. He tried to get me to represent him in his current legal woes. I only meet with him with a retired FBI agent that I use, so I never had any one-on-one meetings with him. So I can't give you anything of benefit. You just have to do the right thing because it's the right thing. And ultimately, he sat down with me. We sat outdoors in a parking lot, and I had my computer, and I read him every line of his transcript from the trial testimony. And each line, I'd say, "Is that true?" He'd say yes or no. Well, what's not true about it? And he would admit to all of it. And then we wrote up with his assistants an affidavit. And we went to a little printing shop around the corner that he knew the guy. We printed it off, and he got 3 notarized copies, walked out and said, I feel a weight off. I feel a weight off. I've always felt bad about this. Now, he ultimately recanted that recantation because he's still on probation for the original charge, and the state's attorney's office leaned on him pretty hard. And he's actually since passed away. But it was crystal clear to the federal judge, chief judge, that what was going on with this guy. And I subsequently went and found Rick's ex-wife and some other people in Rick's life to bolster the veracity of what he said in the recantation, and to lay out the entirety of all the cooperation he'd done for all these years and all the things that he had not been turned over to the defense that should have been. And with Lorraine, I just flew to Utah. I got in a plane. I flew to Utah.
Yeah.
The ex-wife.
Is she fully recovered from her injuries?
Lorraine Smith now. She's had about 34 surgeries since October of 2005, and the most recent was about a year ago, and she finally had her left eye removed because she'd had so many problems with that.
And she's now resident in Utah, and you went to meet with her.
Yep, she's originally from Utah. She had left her second husband, and moved to Baltimore, where she met somebody online. And when that didn't work out, that's when she met Matt, and they got married pretty quickly. Following all of this, she moved back home to Utah, ended up in the house that had been owned by her parents, and that's where she lives. And we just went and knocked on her door, handed my business card, told her who I was and why I wanted to talk to her, and remarkably, she invited us in. We sat with her for a couple hours. She admitted to some stuff, but she was very, she's an interesting character. Let's just say that. I have since been to Ireland to interview her estranged daughter because she said some things about her grandson whose picture was on the bookshelf, and they didn't ring true to me. So I went and found her daughter and interviewed her, and her daughter agreed to read the trial transcript. And it took some cajoling because I didn't have any power over her in Ireland. But she finally called me. She said, "Yeah, I'll help you," because I read the trial transcript, and my mother lied about everything in that transcript except her name. I mean, she claims that she graduated from the University of Utah and she never graduated from high school. I mean, she lied about things she didn't even have to lie about. And Lorraine's second husband, Michael, with whom she'd been with, 15 or so years, he ultimately met with me and agreed to give me some information, like about how at the time she faked having breast cancer to get a boob job, to get a breast augmentation. I mean, just some pretty amazing things. I mean, Lorraine is still to this day, she's stolen her daughter's identity and opened 2 credit accounts and bought an HVAC system at her home using her daughter in Ireland's identity, even though they haven't spoken in years. So on my second visit to see Lorraine, she admitted to a lot of things. She's a very smart woman. She's very smart, very cunning. And I think she's not well, and she's very sad. We were able to document there's at least 8 prior suicide attempts, admittedly not with a handgun. The facts of that night are such, and the scene, and everybody I've shown it to, even the EMT who never saw the basement, when I showed her, when I went out and interviewed her, she said, "Oh my gosh, that's a suicide scene." I mean, there's all these holiday cards and birthday cards, I love you cards between her and Matt. We know at 9:00 at night, that night, she called her ex-sister-in-law, who said, "I can't talk to you, you're too high." Lorraine finally admitted to being an addict, a pill addict. So she admitted everything. And then after we came back to DC, she reached back out to me and sent me an email and said she thinks Matt should get a new trial. And she ultimately signed an affidavit while I was here. I wasn't even in Utah. It was 3,000 miles away. She signed and notarized an affidavit where she admitted to everything but pulling the trigger. Wow. And that's what we took to the state court. And it took us a few years because you got to go back and relitigate all of that in state court and go through the state appellate procedure to exhaust. And then we got back to the federal judge last August. And in February, he vacated the conviction.
Let's talk for a moment about your client. What's in store for him after serving? He had been sentenced to a life sentence for the attempted murder and concurrent sentences for the crime with a handgun and
yeah, he got life plus a concurrent 20 years for the underlying
and he had by this time,
by
the time he was released now just a few days ago, he'd been serving now for 6-7 years. Is that right? How long?
No, almost 15. He's been in since October of 2005. So it'll be 15 years in October. Man,
years in prison. How old is he now as he gets out of prison?
Mm-hmm. So he's born 19, I think he's 66.
So what's in
So
store
54.
for wrongfully convicted, now released 60-some-odd-year-old?
So this is the problem, right? We're not really there yet, right? The system, as I said earlier, is about finality, not getting it right. And you have many, many cases. I mean, the average, and I'm sort of freewheeling on the numbers here, but I think the average time between exoneration and release is something in the neighborhood of 2 to 3 years. So we know people are innocent. They're sitting in jail. DNA has exonerated them, excluded them from the alleged rape. It was a single person rape. It matches somebody else who's got multiple rape convictions, right? And it still takes almost 2 years or more to get that person out of a cage, right? Because the system is so focused on finality. So I think there's two things that are happening. One is Matt's sort of got to figure out how to reintegrate himself into life, right? When he went to jail, as he tells me, there were no smartphones, right? There were no iPads. There was very, very limited, dial-up AOL, that internet, He's learning all that stuff pretty quickly. He's living in a house with a friend and her husband. And they've set him up with a computer and a phone and a bank account. And he's right now in home detention, as we all are, for pandemic. But while we factor in this reinvestigation and what's happening with the appeal, so he's getting sort of a slow reintegration into society in that way. They're building a big garage behind the house where he's staying, and he's a carpenter by trade. So he's going to be outside in the fresh air, eating home cooked meals and doing some carpentry for the next few weeks. I think if this goes the way it should and the reinvestigation comes to the only legitimate conclusion, which is he had nothing to do with this, this is self-inflicted. The forensics make that clear. The timeline makes that clear. I mean, he essentially has an alibi being in jail, being processed for the initial false allegation of domestic assault, right? And I say it's domestic because there's no evidence to support it. He's always denied it. And they lived in the house with his father and stepmother, who testified on the record at the time. There's never any domestic violence between them. And she then went and filed an order to try to be kept from being thrown out of the house, as all sort of the hallmarks of a false domestic violence allegation. And certainly in light of the fact that she falsely accused him of this shooting. So he's got essentially an alibi of being in police custody at the time she was shot, because the forensics say she had to have been shot at least an hour before 7:08, and he didn't get released according to police until just before 7 o'clock. So, and that's still not released, doesn't get him home. And then it totally discounts the neighbor who said, whether it was 6:58 or 7:01, she said he never went in the house. That's the sort of salient fact. So if they reach the right conclusion and they withdraw their appeal, because I don't think they would win the appeal anyway, it's a super well-written opinion. If they withdraw their appeal and the state says we're not going forward, the case will be dismissed. The next step is a petition for a writ of actual innocence to the governor, which I have a high level of confidence that we would be able to obtain. And then he would become eligible for payment. Maryland is one of the more progressive states that has a fund, and it pays. I think the last one they just authorized was for 4 exonerees a few months ago, and it worked out to about $78,000 per year. So he gets a payment about a little over $1 million. And let me make this clear so everybody's paying attention. We're not making a penny. This is a complete pro bono case. If Matt gets $100 million, I'm not taking a beer from him, right?
It's just amazing.
This all goes to him.
Yeah.
But he'll be eligible. So if they fight the appeal, depends, right? If they fight the appeal and they win the Fourth Circuit, we could go to the Supreme Court. Probably the only Supreme Court worthy issue is this jury waiver. Or we could go back to the district court, and the district court could then rule, as the judge made clear, on the ineffective claim, and then they may go back to the Fourth Circuit. And then ultimately, when the appeals are done, assuming that it's not done by being dropped, the state has the right to retry it.
Which seems unlikely, though, at this point, given all the evidence that you've been able to present.
The snitch is dead. That's right. I mean, the snitch is dead. The jailhouse snitch is dead. The complainant, Lorraine, not only gave us an affidavit, she then gave a second affidavit that the state wrote for her. And on the witness stand, she disavowed pieces of that. For example, the state wrote in her affidavit, "I have no substance abuse issues, no pill addiction." And I got her on the stand, and she said, "No, I'm a pillhead." She admitted it. So even the second affidavit, so she's completely incredible. And there's no physical evidence that connects him to the case.
Well, Mark, I appreciate you sharing the story with us today, and wish your client a lot of luck, and the right outcome. Borrowing on the terms we were using earlier, this is a case where our procedural system did not come out with the right substantive result initially, and is winding around towards that now. He's out of jail, but he's still not out of jeopardy, it seems. Hopefully that works out right. It seems as though it will, but he can never get those years back. Even slightly more than $1 million, as you described there, is no compensation for all of that time. And for a person who's been out of society since before there were smartphones to be introduced today, what an uphill climb it seems we've placed on this man. I was thinking of the Just Mercy movie. There's a moment in there when they describe for us, or maybe it's notes that are provided towards the end of the movie, that for all the persons that we have executed in American history, we've now found, for every 9 to 10 that we've executed, we've now found a person who is actually innocent. So that not only are we taking liberty, but we are in cases taking lives, and almost assuredly of innocent persons. It all because good people are working hard to convict wrongdoers, and yet because we're human, we sometimes get it wrong. And all that highlights the great importance of the kind of work that you do in persons like you do to keep our system honest and keep the procedure just. Do you have any parting words for us as we sort of wrap up here?
No. The only thing I would say is it's I think it's really, you're right in some regards. It's about really good defense counsel, and the adversarial system is premised on this idea of some sort of a equipoise between the two sides, which it's not, right? The defense counsel never, even Bill Gates couldn't stand up to the power of the federal government, right? No individual can stand up to the power of the government. So it's never going to be quite equal. But I think what we're seeing, and I'm very happy about, is a movement, let's call it an awakening of the American populace, right? Serial was the most widely listened to podcast in American history. It's the most widely listened to radio podcast in history. Right? That's amazing. About the Anand Syed defendant from Baltimore, who was convicted and sentenced to life for murder, and who incidentally had a cell a couple down from Matt at the North Branch facility. And you've got the Innocence files, Netflix. It's number one right now, trending across America on Netflix. And you've got the Just Mercy, and you've got these, Pulitzer Prize winning books. CNN lead story I saw today was about a guy exonerated, the longest serving innocent man, 48 years, who was exonerated. There was an amazing article a couple years ago about a gentleman who was executed in Texas for allegedly setting a fire that killed his family. And the evidence in that seemed to be overwhelming that it was a accidental fire. He had nothing to do with it. And if you read that article and you're not angry, you're not reading it correctly. And I think as people are starting to realize, and you're starting to see it make its way into popular culture and into movies, whether it's Denzel Washington playing the hurricane, right? This has always been an issue. Dylan's song, The Hurricanes, from the 60s. We've always known this was a problem, particularly in the minority communities and the underrepresented communities and the people at real disadvantages. And now we're starting to see mainstream acceptance of the idea that even good people, the people that we like, that are prosecutors and police officers and judges, they make terrible mistakes, and judges get on the bench often because of political considerations, not because of competence. And so all of these things together can create a perfect storm where innocent people can be accused and can be presented. And so now you're finding witnesses that are being more careful if they're not involved in the case and they're not getting a benefit, to say, well, maybe I saw that, maybe I'm not so sure, and understand the inherent unreliability of eyewitness testimony, particularly cross-racial. You're seeing jurors, right? You're seeing interviews with jurors. I just watched one the other day on something, and it was talking about jurors. They're like, well, we sat in the jury, we really thought he did it, but man, there were some holes in that case, and they understand reasonable doubt. And I think the more you would have thought Kill a Mockingbird would be enough, but you have to make it more personal. And for most people, particularly in the last 20 years, trying to identify with an uneducated African-American living in a Jim Crow South, right? It's really hard to make that identity leap, right? As much as lawyers, we all love Atticus Finch and Scout and the story of Harper Lee, it's really hard to make that connection. And so the more and more that we're getting out there, and the more and more that we're getting people to see what really is happening and see how the sausage is made, the more we're holding the government as a society to their burden. And I haven't seen very many guilty people walk free when the power of the government comes after them. It's very, very rare. It's extremely rare. But the number of people that I have seen that are innocent or grossly overcharged is too many to count. So I think to the extent that people are watching this and there's a message, we got to keep getting this message out. We got to keep talking about these exonerations. We got to keep reading these books. We got to keep looking. We have to continue every day, like all of us do, whatever our chosen profession is, to think, what do I do to make this better? Conviction integrity units in prosecutors' offices are a great idea. Every single one should have one, right? You need to have that other voice. And I think we're trending in the right direction. We've got a long way to go.
Well, Mark, thanks for your story, for your great work, for your service to the profession, and I want to thank you for that. Maybe if I could ask you just to wrap up, before we started rolling tape, you read for me a quote, coincidentally from Atticus Finch. Do you have that with you? Mm-hmm. Can you share it with us?
Yeah, I'd be happy to. I had sent a little note with a photo to all my team members, and there's about 19 people that were actively involved in this case to get Matt to that day. And I sent him a little note, which I will keep for myself. But in the bottom of the note, I put a quote to send that I put on the frames for everybody that was involved. And the quote is from To Kill a Mockingbird. I wanted you to see what real courage is, instead of getting the idea that courage is a man with a gun in his hand. It's when you know you're licked before you begin, but you begin anyway, and you see it through no matter what. You rarely win, but sometimes you do. And that was Atticus to his daughter.
Thanks, Mark. Thanks for being with us today. And thank you for being with us today on TendingBar. I hope you found that story as inspiring as I did. Certainly grateful to Mark for his terrific work. We wish the best for his client. I hope you'll join us back here next time as we continue talking about the purposes and higher calling of the legal profession, and for all of us who are trying to serve the public interest and the greater good. Join us again as we TendingBar together. Thanks.
Hey, I never thought this day would happen, guys. Man, I want to say thank you so much. You'll never know what you've done. Welcome home, buddy.